it stops, no one knows. We're going
Hi, everybody. Welcome back, and still happy Wednesday. I appreciate you guys could automatically get a tiny human interruption. Hold on one second. Goodness gracious, right off the bat, I'm like, what in the world? Hi, yeah, 2 lives in one day. Hi, voices behind the wall. I know, I'm like, oh. So as you guys notice, my camera is off. I'm just exhausted. Sleuthy, if you want to come up, Travis, if you'd like to come up. I'm going to go through a couple things first. We have another new filing that has dropped at the end of the day today from an attorney that some of you may recognize his name and some of you may not, but we're going to go through and I'll tell you about him. But I'm honest, I'm just like, I'm literally going on like 3.5 hours of sleep, and I'm just like, I'm so done. And then Delphi just has to, you know what it does. It just has to hit you twice in the same day. So let me say hi to everybody really quick. And like I said, if somebody wants to come up and help, they're more than welcome to. Hi, Amy. Hey, Mama. Hi, Bonnie. Hi, Jen P. What's up, Jen? Is anyone else exhausted? Yes. Hi, Malicious Intent. What's up, Anon? Oh, Spinster, thanks. I appreciate it. He just constantly wants junk food because he doesn't ever stop eating. Cats, cars in California. What? I love that. Cats, cars in California. Hey, AH, sweets, salty, sweet tea. Hey, Brian, thank you for liking and sharing. Hey, Mama. Ariel. What's up, Petunia? Peggy. Gambies. Hey, Lindsay. Another filing. Yep. I told you guys this morning, if you were here this morning, I said, if one comes out this early in the day, I feel that we're going to get a few. I will drop you a link, Travis. Give me 1 second. Actually, if you just give me 1 minute, let me go through this really quick. And then because I would love your help on this motion. So thank you to Sleuthy Goosey, who was actually able to get the motion, and she sent it to me. And I'll be very, very honest. I read it and I was like, I don't know if I'm just overtired or if this is a lot of legal talk. It's a lot of legalese in this document. So I had to like sit down and reread it a couple times to break it down. Normally I can kind of wrap my mind around things fairly easily. And this one I was like, okay, this is going to take a minute. This is done by his name is Michael Osbrook, and you guys may recognize his name if you are familiar with Murder Sheet. He actually did an interview on Murder Sheet back at the beginning of December 6th of 2023. And it was actually a very, very good conversation. I would play it for you, but you know how that goes. So I just want to tell you guys a couple things about him. And then Travis is willing to come up and help me go through some of this because you're going to look at my document and you're going to go, holy crap. It's like Sleuthy times 10 with all the different highlightings and everything else. And it just is what it is. So he's been an attorney for 30 years. If you listen to the Murder Sheet podcast, you will know some of these things. He is a law school teacher. He teaches at Moore Law School. He's actually a habeas lawyer. And one of the things he says on the podcast, which I thought was extremely interesting, was the way he describes himself. He said, like, it's that the habeas lawyer is like the person at the top of the hill during battle, watching the battle happen, and then when it's over, they come off the hill and shoot all the survivors. I was like, dang, that's like hardcore. He's also part of the board of public defenders in Indiana. If you remember, they're one of the amicus that were filed on the original actions for the Supreme Court. He does state on the podcast that he did not have anything to do with that, although he thought it was very well written. Let me see. I'm just going through some of my notes that I had taken before. A couple little side interesting points that he makes is he actually talks about that he doesn't think that Westerman actually committed a crime and that he shouldn't be charged with anything. He doesn't think that law enforcement should have even been involved to begin with. And then he said that the leak with Woodhouse doesn't matter because it was work product and it had nothing to do with anything, and there was no reason for the attorneys to have to report it to anybody, McLeland, Goal, anybody. He said if during the conversation, some of this is important. The reason I'm telling you is because when we get into reading what he says, you're going to, that was the only interview that was not crap. It was a very good interview. It's some of the things he says in this podcast actually will make you understand more of why he's writing what he's writing when we go through it. So he talks about the conversation between Goal, McLeland, and Baldwin and Rosie, where Goal tells them to essentially stop working on the case, and Nick mentions that he thinks they should probably be disqualified, and she says, yeah, I'm leaning that way myself. And I'm not going to go too far into it because anybody who's here right now, I think all of you guys know exactly what I'm talking about. Otherwise, you're like 20, 30 streams behind the case because it's going fast. You gotta stay with it. You gotta stay up. This is why I have to do another live, because otherwise tomorrow there's going to be 10 other things that pop out. So he said that, well, Nick didn't file a motion to disqualify, so there was no reason for her to halt that, and that was essentially interfering with Richard Allen's counsel. That's going to be important later. They actually do talk about the contempt, and he said that there's no criminal or civil contempt, and he said actually there's no contempt at all because Baldwin and Rosie did not do anything knowingly or intentionally. And I wanted to make sure I told you guys this because that's also very important for what's going to be in this filing that we're going to go through. He said if there was a criminal or civil contempt, that she would have to assign a special judge, and the special judge would actually be the one that has to go over it, and then and that the prosecutor would have to file either a civil or criminal information, and then that would be filed under a separate case. So back in December of 2023, he was already having this conversation. He talks about motions to disqualify. He talks about the criminal and the civil contempt and what the difference is. So, I mean, in hindsight, looking back on it now, it's like he really did. He was standing on that hill and looking down and going, I'm going to watch this unfold and I'm going to see what happens. I'm going to grab Travis a link really quick too. Give me one sec. I'm sending it right. I'm just gonna drop it in the chat, but this is for Travis. So I mean, if anybody else pops up, I'm gonna tell you right now. I apologize. I'm not gonna put you guys on. So just so you know, but I'm just gonna put it right here in the chat for Travis so he can come on and help explain some of this because I'm gonna show you guys. I'm gonna show you guys this document, and you guys are gonna be like, "Wow, what the heck happened?" So that link for Travis to come up whenever he is ready. Yes, so the lawyer that went on Murder Sheet back on the episode from December 6th of 2023, it is worth the listen. I know how lots of people feel, but it's very much worth the listen. He's extremely intelligent. There's Travis. Hi, Travis. Thank you so much for coming up and helping with this one because this one's a lot.
Yeah, kind of a lot of moving pieces to this puzzle. What's intriguing is this case continues to be catching the interest of top-level law professors in Indiana and other defense counsel in Indiana. Very intriguing. There's a top-notch law professor that runs the federal Habius project at I keep saying it wrong. It's Indiana University, I think IU School of Law, and we'll get to that as we go through it.
Okay. All right. So do you want to read it? You want me to read it? You want to just stop me and tell me when I don't understand something? Whatever you want to do, because I just appreciate you being here.
However you want to do it. If you want to hit the parts you don't understand, if you want to highlight your highlights, so to speak, and then go through thoughts.
Yeah. This is my thoughts. I'm like, okay, here it is, all broken down. So essentially,
at least you're not one of those people that highlight and the whole thing's highlighted. So that's good. Go down first. Let's hit this footnote at the bottom of this page, I think. No, next one.
The big one? The big one continues.
No, that's it. That's it. You had it. Go back up. So when we get to that, and I'll let you know where that top footnote's really, really important, and we'll explain why. But so wherever you want to start.
Okay, perfect. I'll just start to read through it, because for me it was there was so much of the same type of terminology that I was like, okay, like I need to pay attention to which sections mean what. So what I ultimately came out with is that there's two types of contempt. There's the civil contempt, and then there's the criminal contempt. And then under each of those is two separate types of contempt, either direct or indirect.
Yep.
And he pretty much addresses all four of those in this at some point. So I was like, okay, I'm going to break it down by the four. So I figured that would probably be the easiest way to explain it to the world. Is there's essentially four sections that we're looking at, but ultimately we're sticking with the indirect because it's already been ruled that even with the way he filed it, it's not direct contempt no matter what. So the dispute seems to be whether it's indirect civil or indirect criminal.
Right. And it was confusing because of the way that it was filed and how it's referred to, and then is requesting a quote information unquote, but we'll get to that. But yeah, direct contempt is something that happens in the judge's presence. Somebody cusses the judge, they create a commotion, they're told to stop speaking or they'll be held in contempt, and they keep speaking. Happens right in front of the judge, and judge needs to be able to take care of that right then and there. And so court has a lot more power to take corrective action right then and there if it happens in the judge's presence. Versus indirect, that somebody violates a court order, but not in the presence of the judge. There's not that immediate need for the judge to take corrective action, so there's the typical due process. But we'll go through that. But okay. You're exactly right. Direct's out because it didn't happen in front of her.
Okay, I'm gonna just type into the chat. Okay, so I'm just going to read through it. And then, like I said, at any point you have something that you want to say, and we'll stop at that footnote because I know it's pretty important, but I'll just read through the beginning of what this is. And just FYI to the chat, I'm not going to go through every single criminal code number and all of that stuff. I'm just going to go over the surface of it and what it is. So this is the counsel for defendant Richard Allen, Andrew Baldwin, Bradley Rosie by counsel now come before the court with their motion for summary denial of the state's verified information for contemptuous conduct, which was filed on January 29th of 2024. For the reasons that follow, the court should summarily deny the state's information. So the introduction is the state's information has many flaws. Not least among them is its failure to allege, either directly or by inference, either Mr. Baldwin or Mr. Rosie committed any of the supposed offending acts willingly. But the state's information has two additional flaws that are fatal. First, to the extent the state's information purports to allege indirect civil contempt. It fails to allege any act injuring the state that a remedial or coercive contempt sanction could redress. The state therefore lacks standing to pursue its information as one for indirect civil contempt, and this court lacks jurisdiction to consider it. Do you want to touch on that at all?
So this is just the introduction. They're laying it out, and what trying to explain here that the court needs to take note of that the motion for contempt filed by the DA's got some technical problems with it that she should consider before moving forward.
Okay, so second, because there is no available remedial or coercive contempt sanction, any contempt sanction would necessarily be punitive and therefore a finding of indirect criminal contempt. But to pursue indirect criminal contempt against Baldwin and Rosie, the state would have to file its information in a separate criminal case. Essentially, Nick McClelland filed his motion to hold them in contempt under Richard Allen's case number. And if it's criminal, that means he needs to file it as its own case number with the defendants being Baldwin and Rosie. And he didn't do that. So
that's absolutely right. Yep.
Okay, so the information in a separate criminal case, it has not done so, and this court has no authority to punish Baldwin and Rosie for indirect criminal contempt in this criminal case against Mr. Allen.
Right. So this first page and a half you've already gone through is he's pointing out that the motion is a mixture of the two. It's asking for criminal contempt, but it's filed under the case number. That the way it was filed, it looks like he's asking for civil indirect contempt, but there's problems with that too, and that's what the attorney is laying out in the beginning here. Did we see, before I forget, did he file a special appearance notice with this motion like Hennessy did yesterday?
Sleuthy, do you happen to know that? I know that this was dropped today, but not put on the docket because the clerk was actually already gone. So I don't know if he filed that along with it because this was from Sleuthy.
Okay, so probably will file it at the same time. Okay, it's just a technical matter. Go ahead.
Okay. So let me see, where was I? Okay, so finally, were the court to impose, without jurisdiction or authority to do so, any necessarily punitive sanction on the state's information in this criminal case against Mr. Allen, it would be at least the second time the court has interfered with Mr. Allen's 6th and 14th Amendment rights to counsel. This is why I wanted to talk about what he said on the podcast, because he talks about that she was essentially out of line when she told him to stop working on the case back in October, and she was interfering with his counsel at that point. So I think that's one of the main reasons too, that he's like, I will get involved because I already saw what she was doing, and if she does this again, this is what it's going to be.
Yeah, so kind of anticipating some questions, maybe people popping up, maybe wondering, okay, is he just filing this on his own? No, somebody reached out to him, or he offered one of the attorneys to address this issue, but in order to come into the case and file this pleading, or get it ready to be filed when the clerk's office opens, whatever the case may be, Richard Allen would have to consent, just like he did with the 6 attorneys on the 2 original actions that were filed. And so he's aware of it. Baldwin and Rosie are aware of it and approve. And that's kind of what the notice of special counsel kind of clarifies. But in case people had questions about that, so this punitive thing with indirect contempt, and again, what the difference between direct and indirect is: direct, it's, F you, judge, you're in contempt. F you, I'm going to, fine you $100 for that. Well, you can fine me all you want. I'm going to keep doing it. F you, okay. Day in jail. The other is, I want you to disclose the name of your source on that would have information in this criminal case. No, I'm not going to do it. I'm going to give you one more chance. No, if you don't, I'm going to put you in jail for 30 days. So it's direct, happening right in front of the court. The reporters declining to name their source, or a litigant or lawyer is acting completely inappropriately right in front of the court, so they can take action. And that's the language that they're using to coerce compliance. That's what they're talking about. Whereas indirect contempt, the violation of the order has already occurred. So the court is more limited. If it, whatever the punishment the court metes out for an indirect contempt, a reviewing court's going to look at, well, is this to punish, or is it to just gain compliance? In other words, it's very difficult to give an attorney jail time for indirect contempt. The case law says that very clearly. So it's kind of reduced to monetary. And really what the court needs to look at is, what's the chance of future occurrences occurring? Are they not taking steps to prevent whatever the contemptuous behavior was? So they're pointing out that, the DA has asked for an information, which is more in line with criminal contempt, not civil, but he hasn't asked for an information that has the proper standard, which is knowing or intentionally, or something that I, in fact, you read earlier, I can't remember, but it's intentional and knowing. So if he's requesting an information that's defective right from the get-go, needs to say, if the court's going to issue an information, that whatever Baldwin and Rosie are guilty of was intentional, is the claim. That kind of answer and go into what you were interested in on that part?
Yes. So essentially, if it was civil, she can't see it. She can't preside over it anyway.
I pulled up those statutes, and on civil, she can preside over it. Criminal, no.
Okay. So because they filed the information, or because he tried to file the information, he is essentially implying that it's criminal. And if it is criminal, then she has to request a special judge to come in
Correct.
and preside over that hearing.
Correct.
Okay, so
now,
before I read further, then I have to
something. He may say something different in here, and if he does, we need to go with him because
I don't think he does. That was my interpretation of what he said. So,
okay.
But I do have to ask you, why would Judge Gohl put this on the docket to hear it on the 12th then?
Well, we can all speculate about that, and that goes back further. Why do some things get scheduled for a hearing? Some things get ruled on summarily without a hearing. We can speculate about that. It's either could be lack of knowledge of the law, could be bias against the attorneys who have been reinstated. Could be a lot of different reasons.
Could it be, because here's what I was wondering, is could it be that she'll hear what is said and then she'll tell them that she'll send that to a special judge? Or would she just, or could she, or would she, I guess would be the question, just order that this be removed from this case and tell Nick that he needs to do it the proper way?
That could very easily be the reason, because for criminal contempt, he doesn't have to get her permission. He doesn't have to get an information from her. He just files an information just like he does in every other criminal case. They file an information, then there's an arraignment, and a magistrate or that judge determine whether there's probable cause. If there is, then it proceeds like a separate criminal case. But there's some fundamental defects in even in pursuing it that way. It appeared to me that civil contempt was the only real avenue that they had, and he's gone about it completely the wrong way. So she may just tell him, look, if you think it's criminal contempt, and I'm not making a judgment on that, what you filed is defective, I'm going to deny it without prejudice, meaning you can refile it the right way, just like you indicated. Or it could be that she said, you've got a mixture of things here, and I can't tell what it is you're trying to pursue. And so, you need to file an amended motion and fix this. So it could be exactly as you say, that the hearing is going to be limited to, you're going to fix this and you need to fix it, and this is how. That is a possibility, but
not a probability.
So you just can't tell with her. It's kind of just unknown. So I'm trying to be as diplomatic as I possibly can, but because normally if something's defective, the clerk will kick it, or if the judge sees it, normally they'll deny it without a hearing to say, it's vague, I'm going to deny it, or what they've alleged is more properly criminal contempt. You need to file a separate action. That's typically how courts take care of stuff where a pleading's been filed that they can't tell what's going on.
Okay.
So but I'm going to say it's equally possible that they're going to have the hearing and they're just going to talk about it, and she's not going to plan on ruling on it. But they need to be prepared. Well, that's a really tough question, because so she set this for hearing on the 12th, and she's along with the motion to amend the information, add the 2 additional counts, right?
Right.
Okay.
Well, 4 technically, but yes, 2 each.
Yeah. Okay. Gotcha. She denied the pending motions without a hearing with kind of one-liner things on the Franks and the motion in limine on the tool mark expert, and granted a hearing on the 2 motions that were pending by the state, which was the motion to add the counts and this new contempt motion. I guess that would be possible, but I'm just really not thinking. I think she's like fully prepared to go forward with it in its defective form. And, this footnote, this footnote,
okay.
number 1, this is the written motion required by Indiana Original Action Rule 2 sub A, which provides in relevant part. You can read that. No petition for a writ of mandamus. Go ahead.
No, you go ahead. Absolutely.
No petition for a writ of mandamus or prohibition, that's an original action, will be entertained unless the relator has raised a jurisdictional question by written motion, which the trial court has denied or not ruled upon timely. The motion shall allege the absence of jurisdiction of the respondent court or the failure of the respondent court to act where it was under a duty to act. So in essence, he's telling the court, look, this filing right here is what is going to get you back in front of the Indiana Supreme Court. We're filing this in order to meet the requirements to take you back up in front of the Indiana Supreme Court. And, I know you understand, and a great deal of your, really smart followers in chat are going to understand how significant that is. You usually don't see something so plain explaining to the court, look, you really don't even need to read past this part. We know what you're going to do. And this is so we can take you back up where we were on the 18th. That's in effect what that's saying. You don't typically see pointed out in footnotes that what this response is, what this motion for summary denial is simply to jump through the hoop to be able to take you back to the Indiana Supreme Court.
If she doesn't do it, if she doesn't do a summary denial.
Well, she can have her hearing and then act like, she understands the law and agrees with this motion and is going to deny it on that basis.
The doggies are barking. all my dog's ears just perked up. They're like, hey, friends. Somebody must have come in. My dogs do that all the time.
Go ahead and read some.
Okay. So footnote number 2, at least one other time, of course, was when on October 12th of 2023, in an email, the court ordered Baldwin and Rosie to stop their work on Mr. Allen's behalf for at least a week. State interference with counsel in violation of the Sixth Amendment is a structural error for which prejudice is presumed. Do you want to pop back in on that one?
Let's see if they stopped. Okay, so repeating what he apparently said during a podcast that you alluded to earlier. But what's interesting to me is that's what the basis of the second original action was, that what they pointed out in the briefs and the oral arguments was that by taking that action, to telling them to stop work, they now had structural error in the case. And so interesting that he's bringing it back. Again, this kind of goes back to, they're just really laying this out plainly for the court. This is the direction we're headed, and this is why you were in front of the Indiana Supreme Court, ISC, on the 18th. You know, it's so rare for original actions to for the ISC to even agree to hear original actions. It's extremely rare. A lot of them get kicked out summarily, denied summarily. Some, like if there's a clear error in the way a sentence was calculated, or they have strict rules in Indiana about how quick motions need to be cited on the civil side, how quick hearings need to be held. And if those deadlines aren't met, the clerk is required to bring in another judge. And so the OAs in Indiana are about that they file a original action under that rule and say, the judge didn't rule on our motion within the time limit, and clerk's required to appoint a judge. And they rubber stamp, you're right, new judge all the time. And then for the second original action, even to be granted, was a huge thing. And then for them to order oral argument on it, that was pretty much the telltale sign that something of those three things was going to be granted. Reinstatement of the lawyers, removal of the judge, 70-day trial setting after it got sent back down. So this part here, this second footnote, he's getting out what he apparently expressed during that podcast, that, look, you just cannot get yourself involved in how the attorneys are handling the defense, whether you agree with it or not. It creates structural error, and to allow that would get the case reversed. And she's actually done this before. I found a death penalty case from 2018. It was a triple homicide, and boyfriend, girlfriend, and two other family members of the girlfriend. His girlfriend was 9 months pregnant. So he got charged with 4 murders and the death penalty. And he had a private attorney, the defendant did. And one of the things you're supposed to do if you're defending a death penalty case under the ABA guidelines and even the guidelines in Indiana, you're supposed to get what they call a mitigation expert, which talks about the whole family history of the defendant and able to, if they're found guilty, be able to put that in front of a jury so that they can understand what the environment that the defendant grew up in, so on and so forth, that be more inclined to give life without parole versus the death penalty. Anyway, he had hired one and she didn't like something about that. And then he tried to hire another one and didn't like who he selected. So she removed him. So it's a little bit different. She removed that attorney, not based on violations of court orders, but she removed him based on what she thought was substandard legal performance in this death penalty case. And she appointed 2 public defenders. Does this sound familiar? Interestingly, in that case in 2018, the new public defenders that came on filed a interlocutory appeal about the removal. So new attorneys point out to the court, judge, this removal is improper. And she denied it. And then they request certification for an interlocutory appeal, which she agreed to. So it went to the Court of Appeals in Indiana, but they withdrew that appeal because the defendant was just going to take so long. It's going to add 6 to 9 months for that to occur. He didn't want that to happen, so they withdrew that appeal. So we don't know, what the court would have done or whatnot. But this is Judge Gull that did this in 2018. And then they ended up working out a plea deal in that case, and the defendant took 400 years, 100 years for each murder stacked or run consecutive. So he took 400, and so we never knew what that was going to be. But so it's just, there's a lot of unknowns with the judge, and I think here again, like footnote 1, they're in footnote 2, they're just pointing out what's occurred in the past, so that if this does have to go up for another original action, they're pointing out that this is occurring again. Maybe they're going to refer back to that 2018 case. Most of the defense bar in Indiana knew about it at the time, and more specifically, the Indiana Defender Council, not the commission, the council, which Hennessy has been a board member of almost from the inception. They were certainly aware of Judge Gull removing an appointed attorney for substandard performance. So it seems to me that while you see high-level professors that are very well respected in and outside of Indiana, why they're getting involved in this case is there's important issues in Indiana that need to be addressed. I don't know if it's just with respect to Gull. I kind of doubt it. I think they see some systemic problems and they're trying to get them addressed. And, this is as good a time as any.
And the opportunity arises.
She's making it easy for them,
Right.
I mean,
exactly what I was thinking.
PFD won that first OA, hands down. That's Maggie, was the main author on the first brief, dealing with filings and how to protect confidential information. And her brief was so effective that the judge issued that order, which in effect mooted everything that they had requested. And so the order says, petition denied at the bottom. But if you read all of that language, where the Indiana Supreme Court said, we're going to take the time to explain how this act that we have, the Access to Court Records Act, I can't remember the initials, ACR, we're just pretend it is.
I think that's right. Yeah.
Wow, lucky guess. We're going to explain how the ACR really works in Indiana. And then they proceed to quote pretty much line for line, step by step, that Maggie, who, I've dubbed PFD, Princess of Effing Darkness. They lay out, line by line what she sets out. So it's clearly a win on that. And then, as skeptical as everybody was, they got oral argument granted on the second OA. And, I think this second footnote is just laying out for the record the history of the interference.
Right, and so the second one continues down to the next page. And so there's a part here that I found pretty interesting. So he's essentially telling her, like, you've already done this once. You did it on October 12th, and now it looks like you're potentially going to do it again. And so it's kind of like foreboding, I guess, like this is what's going to happen if this kind of thing continues. Like, were Mr. Allen to prevail in the undertaking of a conditional writ of habeas corpus, though using more formal legal language, it would look something like release Mr. Allen or leave his attorneys alone.
Right.
So he's saying, like, if I had to step in as a habeas attorney, yeah, this is where we're going to end up. I will come in as the habeas attorney, and I will tell you that you've already done this twice. You're committing structural errors. You've done it twice to the same defendant. You're either going to let him go or you're going to leave him alone.
Right. So it's real direct. I was surprised how direct it was, but maybe that's what's needed. I mean, it's very direct that this pleading that we're filed in footnote 1 is really the hoop that we have to jump through for a third original action. And then I apologize, go back to where you were. Before I joined you here, I kind of put a teaser in the chat about, did you all catch, footnote 1 about what we just went through? And then, he's a habeas attorney. So yeah, he runs the habeas project at the School of Law at Indiana University, and is laying out that I think it was a little bit above this one.
Is it in this part?
Yeah, where he's talking about, he cites a case where federal habeas was granted, and I don't see it there, but compel Allen to seek habeas relief in the form of an injunction. And
Yeah.
so he would file a writ in federal court ordering the judge to quit messing around with the defendant's right to counsel. And there's precedent for it. So again, directly letting the judge know what the possible consequences are. And then, it's no coincidence that his expertise is federal habeas and teaching law students about federal habeas. Now, I don't know, if you mentioned anything about that in the podcast. I had mentioned a while back that could be one of, in terms of the way that they're housing Richard Allen, and if the way if he doesn't have meaningful access to his defense lawyers, that's another area that's ripe for federal habeas. And then if the conditions are substandard that, they were talking about, but it's pretty hard, sad to say, pretty hard to get a federal court to find that a state prison is below standards. It's just got to be really horrendous and egregious. But federal courts all the time are get involved, and there's the possibility the federal court may have to take over a county jail because they fall below standards. What they typically do is give them time to get up to par, and if they don't meet that deadline, they take over. Federal judge takes over the jail, and then what happens is they take over the jail. They put in new employees, redo the whole thing, and then the federal government sends the county a bill, and they have to pay it. And so it's like the last thing on earth that a county wants to happen. And so you'll see state judges, that are in that particular county, if the jail is not providing, for example, mental health services, the jail needs to either, if they want to operate a jail in that county, they need to either have mental health services. That's been the law and the requirement for decades. You got to provide health and mental health services in jail, or they need to transport him to a mental health provider or a doctor. That's the way some counties take care of it, but they need to do that. And I've seen judges have to order certain things. I just don't understand it. It's kind of this, things are backwards in Indiana in some ways. It's no, you don't say, oh, well, we can't house them. So, this prison's willing to take them. And that kind of wouldn't happen in the, now, if somebody with a severe mental health thing, they're sent off to the state hospital and made better and then brought back. But, I didn't see that as being the issue. Most courts I'm familiar with, they would have ordered the sheriff to get up to standards. Either, I'm giving you 30 days to either hire a psychologist or mental health care provider that meets the standards, or you need to transport them. But apparently that county has got real fiscal issues, and I base that on that auditor going to the board of supervisors, the commissioners, for additional funds to hire that second attorney, prosecutor, that, you know, they don't have a lot of funds to work with, it seemed to me. I know there's a lot, you and others know a lot more about that in terms of the funding issues and whatnot, but
I just know the request that they put in because it gets recorded and then put out, and then I watch them. So I just know that part of it. I know that they request, you know, different funds for certain things when it comes to, especially the Cleveland, but I mean, I don't know their budget.
Yeah, I heard something about there was a request for another extra 5,000 or something. You know, I don't know, but and somebody had mentioned that somebody in the county said, you know, we can't really afford to even try this case. So, you know, and that's a problem because according to the law and the Constitution, the defendant doesn't bear the brunt of that.
Right.
Either got to let him go, or, you know, raise property taxes to where you can do it, you know. So, anywho, so that's what I thought that second footnote was about, and this federal habeas stuff's pretty serious business.
So a lot of this is the rest of it is kind of repetitive in nature. I mean, I don't know if you want to read through it or you want to just talk about it.
Let's let me look at the head note here. So why don't you read that number 1?
Okay, so the state's information has not alleged an injury a civil contempt sanction can remedy. The state therefore lacks standing to pursue its information as one for civil contempt, and this court lacks jurisdiction to consider it.
Okay, so yeah, it is repetitive, and it's talking about direct versus indirect, and that green part is just repeating again that indirect is outside the presence, direct. Indirect contempt, which is an issue in this case, involves, and they're quoting another case, involves those acts committed outside the presence of the court, which nevertheless tend to interrupt, obstruct, embarrass, or prevent the due administration of justice. So, yeah, it did happen outside the presence of the court, but what happened here doesn't rise to that level. That's why he's cited that case. And then going down below, none of the acts the state's information alleges were contemptuous occurred in the court's presence or about which the court itself has knowledge. Citing another case as an example of indirect. Scroll down. Let's see what you highlighted here up there in yellow in that footnote.
Oh, that's the footnote that we read about where the habeas Mr. Allen or leave his attorneys alone.
But I like his artful language. So you all who watched the oral arguments, you all remember that it was very early within the first few minutes of the relator's argument, Baldwin's attorney's argument, and the Chief Justice, who sits right in the middle, she says, interrupts him. Hey, my concern is getting this case back on track. And I wrote a big note. Well, she obviously thinks the case is off track. Well, look at his language. Mm-hmm. Would release Mr. Allen or leave his lawyers alone. But win or lose, federal court is not a railroad siding. Chief Justice Rush likely had in mind when she said at the hearing on the second original action involving this court in this case, my concern is getting this case back on track. I just, again, a very direct approach.
Do you think that she'll hear it or see it or pay attention to it? I mean,
Well,
that's obviously very opinion based, but still,
well,
I'm just
well, so
yes.
Hennessy took the same approach. He filed that brief, and they before the that in chambers hearing spectacle. She didn't even really let him speak on behalf of Baldwin, and then from what I understand occurred on the 31st, because she didn't allow cameras in on that deal. Baldwin, she did allow to speak at that thing, and he laid out very clearly. Some commentators described it as he was lecturing the judge, and turns out appropriately so, lecturing her, look, you can't do this, you can't do this. And so, I could see once where you wouldn't listen to someone very experienced, very knowledgeable as to what the law is and what the problems are with what you did in that in chambers hearing. And that worked to her detriment, not to give Baldwin's case law and argument more deference. But, it's just hard to predict with her. I don't know if she's going to give this any serious consideration or not, but she should, based on who wrote it and what the arguments are. If there's nothing else on that, read heading B.
I want to make a comment though too, because I would think that at this point she has to realize the attention that she has garnered from so many high up legal people in the state of Indiana. Like, they're all paying attention to what she's doing every step of the way. How does she not see that?
Yeah, even the Chief Justice of the ISC was aware of what was going on in the court. She mentioned one of the recent filings, was it the contempt something? Oh, the motion to amend was filed the day of the hearing, and the court was aware of it, right?
Yeah, and it was like it was filed like a half hour beforehand, and she was aware.
Yeah. So, you're absolutely right. At least she's aware of what's happening. My understanding is, like with the U.S. Supreme Court, 9 justices, and each one has responsibility over a particular circuit. Like the 9th Circuit is Western states, and Indiana's in the 7th Circuit, which is 3 states. But the state is broken down by area, and the Chief Justice, her area includes the county where Goal is from and the county where they want to try him. So maybe that's why she's paying particular interest, or all of them are aware. But that defense attorney that Bob has had on a couple of times, last week even, I'd asked him long ago, what's the defense bar think about all of this, and were they aware? And he said, entire Indiana defense bar is aware of what's going on, and appalled by a lot of it. And so, yeah, you're absolutely right. But whether that's going to impact a particular judge or not, who knows?
She doesn't seem to care, because she just keeps doing the same thing. That's kind of
Right.
where I'm at.
Well, we're going to know if she doesn't do anything in connection with this one, because it's laid out pretty plain.
So this says the sanctions for indirect civil contempt must be remedial or, did I already read this? I feel like I read this.
No.
Coercive for the benefit of an aggrieved party, and sanctions for indirect criminal contempt are punitive. So I was just, I was going through and highlighting just to understand the differences between the civil, the criminal, and then the direct and the indirect. So that's why you see the different color highlights, because I wanted to make sure that I kind of grouped them together by that, so I understood where he was going with it. So essentially, I think most of this one is saying, hey, this is not civil. Sanctions for civil contempt are for the benefit of the party who has been injured or damaged by the failure of another to conform to a court order issued for the private benefit of the aggrieved party.
Right.
And then sanctions for civil contempt also must be either remedial or coercive.
Right. So what that means is that is to get somebody in compliance. It doesn't really work. It doesn't cover for somebody for something that's been violated, but doesn't continue to be violated. And like allowing somebody to get their hands on discovery documents covered under a protective order and disseminate them. The type of contempt that they're talking about, civil contempt, indirect, is products liability suit. And you have a manufacturer, and the plaintiff is asking General Motors for all of the documents you've received about complaints about this particular vehicle, the brake system. Or a drug manufacturer, we want all of the reports you're required to keep under federal law about the adverse side effects observed by physicians who prescribe your medication, and they don't turn it over. And then you'll hear every once in a while, judges ordered that company XYZ pay $5,000 a day until they comply. That's civil contempt. Those are a couple of examples I think of off the top of my head. And so that's what remedial or coercive, that's what they're talking about. And what is being pointed out in this pleading, this motion for summary disposition, is laying out very clearly and plainly why civil contempt, indirect contempt, doesn't really cover it either. That's what this is about, and they're providing specific case law, and some of these are old, really old cases. 1911 federal case that's showing that. So, but remember, read what you have in yellow highlight there.
Yeah. So this seems to be also something that's put in here. It's like, hey, these laws are older than dirt. Essentially, anybody who practices law in the state of Indiana, at least, should know that these laws have existed for a very long time.
More to the point, any judge who knows Indiana law should know the difference. Unless he's calling her older than dirt. I don't know.
I think a couple people interpreted it that way too. Like these laws are older than you, and I don't think so. I think they're just really old, and she should be very aware of these laws, as should the prosecutor and the special prosecutor.
they're definitely well settled, and I like the way Hoosiers talk there. Pretty plain and matter of fact. Older than
Matter of
dirt.
fact, yep, they're older than dirt. Like, come on, you should know these by now. So then he goes into talking about criminal contempt and the difference. So essentially, civil contempt, direct, indirect, doesn't exist in this case, and it is irrelevant at this point. And that's essentially what he's saying.
Right. And then criminal contempt, on the other hand, is an act directed against the dignity and authority of the court, which obstructs the administration of justice and which tends to bring the court into disrepute or disrespect. So there's not a very good fit there either. Although technically, the state could argue that repeated violations, if they occurred, or meet that definition. And, the sanctions are to vindicate the authority of the court. It's just not really a good fit. And he's pointing out that if it is criminal contempt that they're going after, they should have filed it as a separate case, but it kind of a waste of time. Doesn't even really fit. But laying out the basic law that's older than dirt. Do you have anything else on that?
No, not really, because I think so. For me, it was like what you're saying. He's writing out like one, McClellan doesn't clarify what he's even going for. Number one, civil, criminal, whatever. But if anything, it would lean more towards criminal, even if it doesn't actually fit. Civil's gone, so the only way that this could be viewed in any aspect would be under criminal indirect contempt. And so he starts talking about that.
Yeah, so as you're scrolling down, I know you already covered the denial of the motion to change judge, and she indicated that the Supreme Court's already ruled on this and denied it. Well, technically, and this goes back to older than dirt, technically what the Indiana Supreme Court ruled is that a majority of the court believes that the first ground for relief should be granted, and said so. The attorneys are being reinstated, and then you see this language a lot. Then it said, all other relief requested is hereby denied, and it's older than dirt in Indiana and everywhere else. What that means is that that particular court isn't reaching the merits of that particular claim, which means they're not saying one way or the other. If they, they're saying it's more appropriate for this to get handled down in the court below. When they say all other relief requested is denied, they're not ruling that, oh, she has no bias. Only under the Indiana scheme of things, the way it's dealt with is that judge or whatever judge that's faced with that motion has to make their own analysis, whether they have bias towards the attorneys or the party, or if it could be reasonably, you probably have the language memorized, but an outsider looking at it could reasonably conclude that the judge has bias. And it was never done. That, frankly, is like a total breakdown of legal analysis. So I don't know what's up with that. And then that's older than dirt. And then here we are, older than dirt again. Why don't you read that one too that you highlighted in blue, that heading number 2.
Yeah, so this is the state's information can only be seeking punitive sanctions for criminal contempt. The state filed it in the wrong place. So number one, we were talking about this earlier, that if he wants to file it, he has to file it as its own case with the defendants being Baldwin and Rosie. Cannot file this information under Richard Allen's case. It has to be its own separate case. So the state filed it in the wrong place, and this court ultimately then would have no authority to impose a criminal sanction in the criminal case against Mr. Allen.
Yeah, so that's pretty self-explanatory. Maybe one thing we can kind of add to that to explain a little bit, the motion for contempt that the DA filed, so it's not one of those things where you can say it's fair notice that it looks like a duck, walks like a duck, quacks like a duck. This thing's got duck parts, goose parts, coot parts.
Got some pork thrown in there.
Maybe some pork. Although I won't even go there. Because it wasn't its own case number, but yet it asks for, and notice the word he uses, information. I thought he said information.
Here?
Yeah, you didn't highlight it. That's threw me off. Yeah, the state's information can only be seeking punitive damages. So basically, he's highlighting a part, the request for an information. So that's just logical. I can't think of a really good analogy right now, but information has a distinct legal meaning. Criminal complaint has a distinct legal meaning as opposed to civil complaint, and information can only mean one thing. It's how criminal charges are brought in Indiana and every other state. And then, so she explains that. I think you already explained it even at the very beginning. He's continuing to point out that we got duck parts and goose parts and coot parts, and why under any scenario it's not going to work.
Right, because he doesn't clarify, once again, he doesn't clarify if it's civil or criminal, doesn't clarify if you're going for criminal or indirect criminal contempt, then, and the civil is completely gone. And if it is left with the indirect criminal contempt, then she doesn't have jurisdiction to hear it anyway. And he filed it in the wrong place. He filed it under Richard Allen's. So it's essentially, the whole thing that he filed is a mess. It doesn't fit into any category, and it's all just bits and pieces and parts of all things thrown into one information, saying, "Hey, this is what we want to do." And she's like, "Perfect. Let's have a hearing."
Okay, now, do you see where it says similarly down below? Stop, go back up. Oh, no, you got
right
it.
Here.
Yeah, can you read that?
Yes.
Up to Bagwell. Just don't include Bagwell. Read that.
So similarly, a flat, unconditional fine totaling even as little as $50 announced after a finding of contempt is criminal if the contemptor has no subsequent opportunity to reduce or avoid the fine through compliance.
Okay, so that's a great way, he's pointed out with this Bagwell quotation. For those who aren't watching, just listening, cites Bagwell, a U.S. Supreme Court case, and has this quote about the purpose of contempt, you have to give them an opportunity to either reduce or avoid the fine through compliance. In other words, you're entitled to one clear warning. And if you don't get that warning in the contempt context, not on a phone call, not in a secret chambers meeting, it's a violation if you couch it as criminal contempt. So again, he's just pointing out you can't call this a goose part because this is a duck.
This is a duck. This is a duck. This is not a goose.
Then we can go down to B. Let's see what that says. Okay.
So we kind of covered this one. And information for indirect criminal contempt must be filed in a separate criminal action. That the indirect criminal contempt, the information is in the wrong place, which is we were talking about. It's filed under Richard Allen, and it should be filed as its separate case against defendants Baldwin and Rosie. A proceeding for indirect contempt must be filed as an independent action and must also be prosecuted by the state.
Right. And so cited a 63 case, an 04 case, a 1990 case.
There you go. There's your more older than dirt cases.
Okay.
That have been around forever.
Certainly long before she got on the court. Okay, scroll down to the top of the next page. And she just lays out the basic facts of each of those cases. If there's something interesting in there to you, I can go over it. If not, we can.
No, I was just putting them all together so that I could see which ones all went with the criminal indirect contempt charges. So that's why I highlighted any of those things in blue, so they kind of all just went together.
So to use our analogy,
citing multiple cases that essentially state the same thing. Right.
And he didn't file it as a separate action. So it's got all goose parts and has no duck parts. Again, what is it? And he's just laid out there very clearly. That's obvious to everybody that it doesn't have a separate case number. He's filed it in the current case. So that makes it civil contempt. And he's already pointed out up above, this doesn't really fit civil contempt. Usually the judge is not the aggrieved party. The court in the aggrieved party was civil contempt. And then he's got some. Now this guy's super smart. I would have to go in and read those cases as to what the hell that means. I know what it means basically, but to get into the nuts and bolts of it, you're right. The author of this brief is thinking at a very high legal level, which that's what federal habeas entails, because it is so hard to get federal habeas relief after the EDPA Act. You have to, you literally have to slice a hair into finer parts in order to win them. And that's essentially what he's doing here, is he's parsing out legal logic, under this type of contempt, you need this type of a sanction, and why that doesn't fit this case. And that if you did do it, is what he's pointing out here, if you did do it, that would violate fundamental principles which are older than dirt. And here's some cases where that was held. 37 U.S. Supreme Court case, 1940 U.S. Supreme Court case, 1938 U.S. Supreme Court case. Any questions or thoughts on that?
No, I think you've helped me so much in understanding this. So he kind of just wraps it up in this part here. He also just says, like, not only was the state's information filed in the wrong place, but as written, it also fails to make out a criminal charge. It does not allege that Baldwin and Rosie acted willfully, omitting a material element of indirect contempt. This is not remedied by any reference in the information which defines indirect contempt as willful disobedience of a court order.
So going back to what we said at the very top, he kind of does an intro. This is what I'm going to tell you. Then he tells you, and then in a second, he's going to tell us what he told us. But this part is, again, about that part that a lot of people, when they saw the state's motion for contempt, Ellie talked about it with Bob, that, well, it looks like civil contempt, because it can't be criminal contempt because you got to file that separately. But what she's asking for, well, regardless if it's civil or criminal, we know it's indirect. Regardless, you have to lay out the conduct that you believe is contemptuous, say the leaks, and you've got to say whether it's criminal in a separate action or civil in the same action. You got to lay out the elements, and one of the elements, the essential elements, is that the conduct was done. What is it? Willfully, intentionally, knowingly. You got to lay that out, and that's not laid out in the motion, and so it's defective. And he just restating it again. Wrong place. So here he's just reiterating that if so. I don't know what the state's going to do when we get to this hearing. Are they going to call it a duck or a goose? Well, if you call it a goose, then it's criminal contempt, indirect contempt. It doesn't make it. And he's just laying it out right there because the information doesn't lay out the proper standard. In addition to being technically wrong, it's not in the right court. You need to file separate action. Let's see what he concludes with.
Okay. Just essentially says for the
he did one of those. Okay.
Baldwin and Rosie respectively request the court to summarily deny the state's verified information for contemptuous conduct.
He did one of those foregoing
this was
reasons.
Written so well that I was like, I got to figure out. it was written so well. I was like, I have to like absorb this because it wasn't simply written. It was repetitive, but so to the point, and then with so much legalese backing each thing up, and all of it being older than dirt. I was like, it's going to take me a minute to wrap my mind around. So I thank you for helping me. So I do have some questions though, if you don't mind.
Yeah, please. Can we scroll down to the signature block, please? I want to get his name correct and where he's at. Okay. So, Michael, how are we pronouncing that? Osbrook?
Osbrook.
Yeah. Okay. And it is Indiana University Maurer School of Law, which is a very well regarded law school. And then he heads the federal Habius project. Let's go through your questions, and then maybe we'll have time that you can Google him at the Indiana University School of Law, and we can pull up his professor page, find out a little bit about him. But what are your questions?
Had it up earlier. I had it up
Oh.
earlier, so let me just go back and pull it up.
Okay.
Maybe I just had up his LinkedIn. Here it is. All right, I'll have to go find that. I think I just had his LinkedIn and his website.
Yeah, whenever.
So my first question is then, if this goes through on Monday, and it's Monday, right? Yeah, I think it is. On the 12th, and she holds them in contempt and fines them the $50, like the example that he used, right?
Yes.
What happens from that point? That's when Osbrook or a habeas attorney would step in, or that is when would they have to go back to an original action at the Supreme Court? What would be the next step if she approves it?
Okay, so scroll back up to footnote 1 on page 2.
Okay. Right here.
That is his next step. He will file a original action saying she had no jurisdiction to give the fine.
Okay, and can he do that as a habeas attorney then?
Well, I'm not going to make you scroll down below, but he put an Indiana bar number underneath his name. We're not there's only one specialized bar that we have in the United States. It's the patent bar. You have to be specially admitted to be a patent attorney and represent people before the patent office and in patent court. And you pretty much need to have an engineering or high-level scientific degree to pass the patent bar. Other than that, attorneys can practice anything, only limited by our rules of professional responsibility say that we need to be competent in that area. And if we're not competent, then, we need to bring in other attorneys who are to handle that matter. So, he can certainly file an original action, even though he runs the federal habeas project. He's just, most of his experience, I'm gathering, since he runs the federal habeas project, is going to be centered around handling habeas petitions in the federal court there in Indianapolis. But he'd be able to file the original action. And he's certainly going to be able to handle that if he can handle federal habeas litigation.
Okay. Is it possible now? I mean, obviously, I think it's possible, but I mean, what are the odds that after this is now put out there to the world, that Nick goes and redoes it so that he's filing it correctly to save face?
The hearing is what date you said? The 12th?
Yes.
Which is what?
I think it's Monday.
Monday, yeah. Yeah. Certainly could, but I really don't get the sense that even the pleading, so we've only had one other pleading, well, two in a way. So counsel got replaced temporarily. I'm just terrible with names. So, but the two replacement counsel, one interviewed recently. They came in, they filed a motion to transfer, seeing that they weren't able to have effective private communications with their client, and apparently some of the conditions that Richard Allen was being housed under, they filed their own motion. So that's kind of a outside motion, I'll call it. The only other thing that was filed, Hennessy specially appeared and filed a motion or filed a pleading regarding the removal of Baldwin. He laid it out very plainly and clearly, I thought. She had that for a number of days between the TV spectacle and the 31st. Didn't cause her to change anything. There was special appearance by PFD to force the preparation of the transcript, which the judge wasn't going to turn over without a fight, apparently. But yeah, I do want to comment that she's had really good representation on those first two original actions. The first one that, the attorney advised her, yeah, you've screwed all of this up. You need to fix it. And then, fix everything that needs to be fixed. You're required to fix, and it'll moot it. And she did. And then the second original action, 2 or 3 of the claims of negligence, quote, gross negligence, one being filing that notice of claim on the potential civil rights violations that Richard Allen had. They filed a notice of claim in chambers. The judge said, well, this is just terrible that you filed this, and that's a conflict. Well, it isn't. I mean, what's older than dirt? I don't know. Whatever's older than dirt, I mean, that's not a conflict. It's not a violation of anything. Well, that claim and 1 or 2 more disappeared in the brief that was filed in the Indiana Supreme Court on the second original action. And then there was a shift to incompetence and gross negligence. It was a shift to allegations of ethical rule violations, hoping that might cure it, because in wheat there was and in wheat there was ethical violations, and they were in a conflict, and he was desperately trying to hook that under, but didn't include the spurious stuff that shouldn't have been a factor at all. So going back to your question, she didn't go back and reevaluate after Baldwin's. She did reevaluate on that preparation of the transcript, and they notified the court that was in the process, and that it would be prepared and filed on time in accordance with the Indiana Supreme Court's direction. So listened a little bit, and it was too late for her to go back and fix. Once it got up to the Supreme Court, they granted it, ordered briefs, and then ordered an oral argument. Really what an opportunity for her attorney to go back and say, in the same way that they mooted everything on the other one. But there has been some shift with these other attorneys. So maybe they finally start to look at this and look at the background of this professor, and regardless of what they think of Rosier Baldwin, these other lawyers that have come in, Kara and Maggie, and the others with them,
Mhm.
they're all real solid, all well respected. They had somebody from the same law school that runs the criminal defense clinic, which is that's something third-year law students can do. And if they want to work on prosecuting a case or work on defending a misdemeanor case, we have that at the law school next to me. And people get a lot of great practical experience with that. And I believe that's who was sitting with Kara and the lawyer arguing the thing at oral argument. There was a third attorney sitting there, and I think she was from the law school and is very well respected, if that's the same lady. But I don't know if it's
you're talking about.
Yeah. She was sitting on the far right, kind of almost on the end of the table. And then Kara was in the middle, and I can't even remember the lawyer. I knew it at the time, but I'm just so bad with names. I'm lucky my dogs. I remember my dogs' names.
You're talking about Mark Lehman is the one that was doing the oral argument.
Yeah, that's
well. I don't remember the other lady's name though.
Okay, no, Wheat.
Oh, the Wheat guy.
Wheat. Well, so
I don't remember Wheat guy. It's Wheat.
Okay, all we need is Mark. That's all we need to remember. The other guy is just Wheat. So
he's Wheat.
It's just really difficult to predict. We did see some movement, but I just really think the DA, I just can't even really, I haven't even been able to wrap my head around him filing that motion without the full opinion coming down. And I mean, the court, the ISC could take a dim view of that. They got it, in my mind, back on track. They weren't ruling on the merits of the bias, in my opinion. And then bang, right out of the door, denies the Frank's motion and the other motion, doesn't put a lot of thought into either opinion. There's a fundamental thing missing from the opinion on the Franks, which is that she found that the defendant did not make a, quote, substantial showing, unquote, to merit a hearing. That's a pretty fundamental thing that the case law says. If you request a Franks hearing, you have to give the court enough information to determine that what you're trying to present isn't a waste of time, completely bogus, and it's called, you need to make a substantial showing. And the only way you can deny a Franks hearing is if you determine as a judge that they haven't made a substantial showing. You won't see that language in there. Now, that's in the minute order. I don't know if she's filed a more formal order since then or not. And she may have fixed that.
Not that I'm aware of. She hasn't.
Okay. So, you've got that. And then he files the contempt right away, he's going to add, I can understand wanting to add the two charges, because because he probably thought, yeah, they're probably going to get reinstated. I better get this in. And, if they do remove her and they do a 70-day thing, at least I have this thing pending. But just can't wrap my head around why he filed the contempt deal. I've often wondered, I have no idea on this, but to me, looking at it, it's almost like the prosecutor and the judge are talking, which is, prohibited. That's called an ex parte communication, and it's totally inappropriate, except there's one avenue. When the defense asks the judge to approve funds for experts, investigator, things like that, you call it ex parte motion for investigator, ex parte motion to hire this expert. You're allowed to redact what specifically you're asking for and the funds, and you submit all of that under seal. And it's understood that's so, the defense shouldn't have to be able to give up its strategy that it's hiring a Odin expert or whatever, a tool mark expert, whatever. And so they don't have to, and they don't get, the judge approves the bills, but the state doesn't get to look at the bills to see who the investigator's gone out and talked to, because it's essentially work product. We've heard a bunch about that recently, but that's the one area you can have ex parte communications with the court and not be in trouble. But I just get the sense that the way these things came down and the timing of the way they came down, maybe it's just me. I don't know if anybody else thought about it, but I would have thought, and most people, most of the attorneys I know that have been following the case and looking at it, they were of the same opinion that some people call it a cooling off period. I didn't really see it as that. Attorneys and judges, you're used to not winning on every argument, and even before the same judge, and you don't gloat, you just proceed on and act like professionals, right? But right out of the bat, it was the order on those two motions. Now, she may have been running afoul. There's a 30-day time limit that it was supposed to be ruled under, but I don't think anybody was pressing that. But those come out, they're, not fully explained, and then boom, an order setting the motion to add the counts. And then but there's no ruling on setting that for a hearing right away. Then there's a motion for contempt. Then there's an order setting both of those for hearing. It's kind of, I don't know, to me, it's almost what we're seeing in action is like two people scheduling stuff, leaving the third person out.
Right.
And, I'm not saying that, I'm not saying it's any deeper than that. It could be judges on the phone with him every other day saying, I really think you need a motion for this, and here's a case I found. I really don't think it's that, but to me, there's a reasonable chance that this looks like things getting scheduled were two people involved, but not a third. To my point, the thing got scheduled on a date that I believe it was Rosie was going to be out of state. obviously
Yes.
nobody checked with him. It just seems terribly suspicious to me, the way the timing of these things and the way it's proceeded, that and stuff happens like that all the time, not in a sinister way, but I've seen it where in bigger towns, like Austin and San Antonio and Houston, each court will have a designated prosecutor, 3 of them, court chief, number 2 and number 3. And so they're in those courts all morning, from when court opens to, noon. And the defense attorneys come in, meet with the prosecutors, then they let the court know what they need next. And sometimes the court tells them, no, we need to move this case. It's too old. Client's in jail, or, whatever they need. But most of the time, the prosecutor and defense come up with a proposal. Next setting should be, another arraignment, which is basically more time to look at the discovery, get the discovery, etc. Then there's idle times, and only people will be in the courtrooms, maybe like one defense attorney and the judge and chief prosecutor. Everybody's twiddling their thumbs. And the court will say, well, okay, what do we have coming up next week? Meaning we have a trial docket next week. What are we looking at? Because the court wants to plan logistics. How many jurors am I going to need to bring in? We really don't talk anything substantive about the case, and it's, nothing sinister about it. They're very careful that it's strictly, the oldest case is State v. Smith judge, and the defense attorney and I are meeting tomorrow on that. And then the second oldest case is State v. Jones. That stuff does happen, and there's typically not a problem with that. But I don't know. It's kind of like he's in court the other day on something else, and she's in a different county. I just don't know. But I've seen it happen where stuff got scheduled on me, and said, yeah, you need to be here tomorrow on a motion to raise your client's bail tomorrow. And then I'll call up the judge, and how'd you come up with tomorrow? So, oh, well, Jim, who's a prosecutor I know, kind of first name basis. And he said tomorrow was good. I'm good. I'm sorry. Should have checked with you. I thought I was going to see you. I said I didn't have court in your court this morning. Okay, is that not good for you? But I've been on the other end where not everybody is at the table when stuff gets scheduled, and this is what it seems like to me. But I've gone on long enough about that. I'd like to hear what your thoughts are about all of this, because they're
no, it's okay. There's some questions that are coming up. No, I am absolutely enjoying listening to you speak. So I'm just absorbing what you're saying, and I think the chat is as well. So Charmaine wants to know if it's ex parte or ex parte.
It's ex parte. And so $7 Canadian is worth, I think, about 44 cents. That's awesome. Thank you, Charmaine. I kid my snowbird Canadian friend. It's a very nice gesture. Beautiful. It's ex parte.
Okay, so a couple of people are asking, so can Nick at this point just withdraw the complaint, or he can just say, I don't want to do this, and just take it back, even though it's already scheduled?
Yeah, he could. It's his motion. could say either side has the right to withdraw a motion. The only exception to that would be is if the response to the motion was to request sanctions for being frivolous or saying bad things in there about somebody. And they're like, well, you can withdraw your motion, but my counter motion for sanctions still stands. But we don't have that going on. But yeah, he could just say, I'm file a pleading that he's withdrawing his motion. Absolutely, he could. Or he could file an amended motion, correcting it.
That's what I assume is going to happen now after he reads this. He's going to be like, fine, you guys don't think I did it right? Then I'll do it right this time.
Could be. And if it's criminal contempt that he's going after, then he'd need to withdraw the motion set for hearing and then file it as a criminal action with a new cause number. But this motion also addresses why doing that would be essentially futile.
Okay, so then Radar asks, like, I understand her positions, but why is it even ethical for them to go to a higher court and goal is hearing or deciding on it? It doesn't make sense. So we were kind of talking about, I think we touched on it earlier. Goal puts in that she's going to deny the motion for disqualification without a hearing based upon the fact that the Supreme Court ruled in her favor to stay. So why would she at this point even be considering anything to do with Baldwin and Rosie, knowing that the Supreme Court ordered them back on the case? Why is it even coming up at all?
Well, it was laid out, and the DA pointed it out in his motion. I mean, this goes all the way back to Baldwin's brief. So you cannot remove attorneys in this situation. It's improper. If you think there's ethical violations, you can file a bar complaint. If you think there are violations of orders, you can proceed with contempt. That's kind of the basis of his motion. So that, said this could be done. Now I'm doing it. So that wasn't ruled on by the Indiana Supreme Court. Likewise, it wasn't the Indiana Supreme Court, at least that language, all relief not requested is hereby denied, is not a ruling on the merits. The Indiana Supreme Court, I think you'll see when the full opinion comes out, is going to say we are not, and it would have said regardless of that motion to change judge, is going to say we don't take a position one way or the other, whether there's bias or not. They're free to pursue a motion to change judge if they think that's the case. And I think they would say the same thing about whether it was contempt or a ethical violation. Say, we're not ruling on whether these are ethical violations or not, because they're not relevant to the determination if removal's proper. They're not. If the court wants to pursue something with the bar, we don't take a position on it. They're free to do that. But the court no more ruled on whether ethical violations occurred than that the judge had no bias. And I can't think of a good analogy, but, you know, people who are in some sort of trade, and you start out doing the very basic stuff, whatever, you know, carrying the piece of pipe into the construction area. And then, you know, at some point after you carry enough pipe, they teach you how to cut the pipe, and they show you a particular tool that cuts the pipe. You know, those folks know that you use particular tool on galvanized steel pipe and you use another tool on copper pipe. It's so fundamental that her ruling, that the court ruled there was no bias, it's that fundamental. That, you know, it's like using a wood saw to try and cut a piece of pipe. You know, it's just, that's the best analogy.
I love your analogies. They are amazing.
So go to that previous question. If that's possible. I think one of the other things, so how is it ethical for them to go to a higher court? Well,
I think it's too far back now for me to get to, because
it's okay. Every state has a procedure in what circumstances you can go to a higher court while the case is pending. And one is an original action, a writ of mandamus, and those are very limited. So to answer your question, it's ethical if you meet the requirements that are very narrow for a motion for a writ of mandamus or prohibition. I mean, it's just a handful of types of cases that can be done, and this was one of them, the removal of counsel. Other states, or like Indiana, they have another type of an appeal before the case is done called an interlocutory appeal. And to check the, you know, there's kind of a gatekeeper thing. You have to get certification from the court to appeal that to the Indiana Court of Appeals. And so it's ethical because you have these gatekeepers that control the flow. I hope I answered that question about that. If I kind of missed part of it, please repeat it and specify. And
I'll radar. Yeah, radar. If you didn't get to part of it, because I lost the comment now. So if there was something that
I think I got it, but how is it ethical to go to a higher court? And it is ethical if you meet the criteria. And with the first original action, they met the criteria so much that the judge went in and fixed it. You know, and these are very rare things that have been coming up in this case, that none of this is routine radar. So, you know, it's not routine. So no matter which side you're on, I mean, you could be, doesn't matter, pro-judge or pro-state. If you take these unusual steps, like removing attorneys, that's very rare. And so there's this process that's proceeded. Now, on the bias thing, Indiana does allow that, but Judge Gull has to approve an interlocutory appeal about that. So let's see, I understand not having to go to higher court, but when filing means to seem to. Yeah, so states do that differently, Radar. That's a very astute observation. So in my state, Texas, if you want to remove a judge for actual or apparent bias, what happens is you file that motion and the case stops. Boom. And that was the sound effect. Boom. And it goes to what they call the regional presiding judge, which is the administrative judge that's over like 7 or 8 counties. And then that judge assigns a judge, usually from another county, to come in and hear the motion to change judge. But not in Indiana, and was really surprised by that. But I read the case law, and the rationale is that the judge who is alleged to be biased is in the best position to determine whether they're biased or not. I know that sounds weird, but we trust judges to be able to remove personality conflicts. We trust them to listen to evidence, determine whether it's admissible or not, and if it's inadmissible, to not allow it into evidence. But yet, how are they going to not remember that there's hearsay that claims the defendant confessed to them, but that was inadmissible? How are they going to forget that? But we trust them to do it every day. And Indiana has determined, we think the better practice is, one, they take a hard look at whether they have bias or not, and then also take a hard look at whether, even if they, in their heart of hearts, I like to say, don't feel that they're subjectively biased, whether somebody from the outside looking in, that apparently they're biased. And I've read all of the cases on it in Indiana, and they feel comfortable with it. But the federal system's that way too. And it's similar on contempt as well. That's just the way they do it. But
so
I
have a question.
I know it was puzzling to Allie. Allison just still can't wrap her head around it.
So I was doing some research on this whole Supreme Court. Can they change their opinion because it's not written yet? Can they actually go in and change the decision that they made? And
absolutely.
I don't, from what I was going to say, from what I found, it seems like they can. Because it's not permanent yet. Is that a correct way to describe that?
Well, they haven't. They issued this preliminary thing, but all the time they'll issue rulings where they agreed to hear an appeal from the Indiana Court of Appeals. It's discretionary in those types of cases where, like the U.S. Supreme Court, you apply up there. It's called a motion to transfer, asking the Indiana Supreme Court to hear the case that the Court of Appeals ruled against you on, and they'll grant the review. They'll get briefing. They read all of the briefs and go, this is an important area law. Why did we grant this? I don't know. And then they'll issue an order improvidently granted. In this situation, what the normal process would be is, after the full opinion is filed, either side can file a motion for No, they can't. Not on an original action. Strike that.
Okay.
Because there's
Strike
not
that.
an official full opinion. Because when they do the full opinion, they got to essentially, in effect, vote again. So someone's going to write that full opinion, and then we know that there's at least one judge who voted against reinstatement. There's 5 members of that court. Could be 2, could be 3-2. One of those in the majority writes the full opinion, circulates it, and then one of those 3 could say, "Well, I'm not signing this. It says it says this standard, and I don't agree with that." So they either figure that out and come to a resolution to where they can get that judge to concur instead of dissenting, or it flips 3-2 the other way. And but it would be rather rare. People were commenting, well, they already made up their mind. They should have had an open mind. A trial judge hearing a case where they're the finder of fact, they need to be fair and impartial and not prejudge the case. Appellate judges are supposed to prejudge the case in a way and then determine, is oral argument going to be helpful? And yes, it is, which they ordered. So they probably had 90% of it figured out. And it's possible they circulate an opinion where it becomes unanimous. It'd be very, very unlikely, I would think. They've issued, PFD told me, I asked her what she thought, how long it was going to take. And she mentioned that they've been doing this thing where they issue something very quickly that gives the decision, and then they give a more detailed opinion. But the Indiana Supreme Court's at fault a little bit on this. It's not all Judge Gohl and the attorneys when they said, we're going to issue a more detailed opinion quickly, but this case is not stayed while that opinion's coming, which is basically telling both sides and the court, go forward with what you need to go forward. And part of that was at, Richard Allen's counsel laying out, which he had to do, and he did very effectively, the delay and the harm this was causing to Richard Allen. So they did this quick opinion. They said details will come, but the case is not stayed while our opinion is pending. Well, right. You're waiting for our opinion. Go forward with what you think you need to do. Don't wait for the opinion, which is, now in hindsight, when, not knowing, contempt motions and pending motions that have been sitting around since August in at least one case get decided within a couple of days. And this is where we're at.
So they want to know, can the Supreme Court do anything like outside of what the original motion was by seeing like the stuff that's happening now? And it kind of goes along with another question that was asked.
Like no, they already not saw really. They can't reach down and grab the case. It would have to be a new original action, which you have up there now under footnote 1.
Right.
That, if they proceeded and they order, but and where all of this is going in kind of a roundabout way is how does the defense get the removal of the judge back before the Indiana Supreme Court? And which is a great question. They have where a judge has gone really, really rogue. There's a case in Indiana Supreme Court. They had a special judge come in and sit on this case. It was 2 county employees, 2 ladies, and the county hadn't paid them. And they each filed a separate lawsuit against the county saying, we want our paycheck.
Mm-hmm.
They typically, when county employees, anybody is within the county is suing somebody else in the county, they appoint an outside judge. So this outside judge came in, and he got the case, and he set it for a contempt hearing. Said without really calling it a contempt hearing, he ordered all of the county commissioners, board of supervisors, to be in his court on a certain day at a certain time. The county attorney who prosecutes or defends civil suits, and the 2 ladies who are owed money and their attorneys, everybody in court. And he has the county auditor in there who I guess approves payments like a treasurer. And he says, I want, okay, what's the deal? When are we going to get these ladies paid? And he didn't get the answer he liked. So he ordered the auditor to pay these 2 ladies their money, ordered them to go down and get the checks at the bank. The county attorney tried to say something. The judge said, I don't need you in here. Get out. You're in contempt. Sheriff, remove him. Then another attorney in his office stood up and said, well, I represent him. I'm trying to figure out, we don't need you in here. Get out. Long story short, by the end of the day, the 2 ladies had their checks, cashed them, so the county couldn't go back on that. 5 people were held in contempt. Then the county decided they wanted to appeal all of that, and they filed an original action in the Indiana Supreme Court. They wanted a record, transcript of the proceedings. The judge said, I won't do a transcript unless you purge the contempt, which is similar to, fighting the transcript, but real egregious stuff. It got to the Indiana Supreme Court. They just removed that judge. It said all of the prior rulings are null and void. The new judge needs to go in and reconsider everything. And then they commented that not preparing the transcript of the hearing was just adding more evil. That's their term, more evil to, the conduct before. What's happening with Judge Gohl up to this point, doesn't rise near to that level. Maybe a judge or 2 in the Indiana Supreme Court might think it rises to that level, but I don't think a majority would. So there is precedent that if you get back up in front of the Indiana Supreme Court, one of the things they can look at anytime they feel an original action is appropriate is whether the judge staying on is appropriate. So if this somehow ends up as an original action because she grants the contempt, And the Indiana Supreme Court agrees that it's appropriate for them to look at as an original action, they can ask yet again, not because of structural flaw so much, but because we're up here yet again, court not understanding or following the law. So that's how you'd get it back up there.
All right. Let me see. There's a couple more for you still. Hold on. Okay, so I'm gonna switch topics really quick for a hot second. But from what was happening, like this morning, did you hear all the stuff that happened with the DVR deleting all of the recordings and so on and so forth? Okay, so
yeah,
Luis
just a
is
little
asking,
bit.
yeah,
I got the gist of it.
So what do you think of the fact that everything was deleted from that time frame? Well, we know of at least 2 interviews that were supposedly deleted in the time frame, but they make it seem like anything between those dates is gone. Everything was overridden.
Well, I don't know enough of the underlying facts like you and Bob and others
would it
do.
be enough to remove Nick?
But it seems sinister to me that those are, what's missing. And it's, I know that there's been a number of depositions that were taken. I know that, certain things were revealed, which have to be just by the nature of your questions in a deposition. The other sides kind of know where you're going with stuff. And then what a boondoggle. Now, so there's a Supreme Court case that defense lawyers, any kind of lawyer you're familiar with, Youngblood v. Arizona, which got cited in that motion to dismiss. And it's a high standard that we have to show to get that to work. That was actually part of the Avery case with regard to the bones. And but Indiana, I was reading the cases in that brief. Well, first, I thought it was interesting that they changed the name for Richard Allen from defendant to accused, unless I missed that before. Seems to me prior motions listed state versus defendant, but they relabeled him accused, and there'd be a reason for that I'll go into later. But
in the one from today?
Yeah, the motion to see, it says accused.
Good catch, Travis.
And they refer to him as accused in the body of the motion rather than defendant.
Yes, they do.
I'll explain what I think that is later, but so the that's suspicious on the timing, but the cases cited in this brief here, I was surprised that Indiana has a lower standard. You don't have to show an evil motive of the state, intentional. According to the cases cited, negligence, or I don't know if they said gross negligence, but
I don't think they did. I think they said
that would have been cool. But
grossly negligent. I think
let's
it's intentional or negligent is what I think it says, but I don't want to.
Yeah, keep going down. You'll see some case down, more.
Yeah, it's been a few hours since I've looked at this, so I don't remember everything is now.
Yeah, just look for a talus. Well, anyway, oh no, there's a whole no, there's a memo. There's a memo,
Yeah,
separate memo.
right here.
But anyway, those
Yeah.
cases cited in the memo, there's some right there.
Yeah, it's also the accused.
They talk about that, negligence can be enough, negligent destruction of evidence. Now, even more to the point, she got to order a hearing on this. I don't think there's any way to avoid that. And that would be grounds for possible interlocutory appeal, not an original action, but an interlocutory appeal, the denial of a hearing on it. So that's going to be interesting. I don't think it would be granted even with a hearing. It's pretty difficult, but just well, I'm sure after the Chief Justice of the ISC saw this and the she's not sitting home at night watching whatever she watches thinking this thing's back on track.
No, far from it. Okay, hold on. There was another one. So she still has not denied the motion for the continuance for Monday's hearing. This is a couple of different people asked this. So
Sleuthy, yeah, you'd be right on that. Normally you'd see an order issued, and here what would happen is the legal assistant or secretary, whatever you want to call that works for the judge or multiple judges. In Texas, we call either the judicial aide or the court coordinator, depending on the county. The court would see that, kind of look at it quickly and go, oh, we didn't check with everybody, or I didn't check with everybody. Okay, call. And the court coordinator would send out emails and make some calls and try and figure out another date, and then would issue an order, and it'd eventually make its way into the court file. But I'm assuming you all have looked, and there's not even a minute order about it, saying it's granted and it's continued to another date, absent a minute order or a written order in there, and absent their system. I've seen where it says hearing canceled by, it'll say the court, and then it'll be scheduled again. But unless y'all are seeing that in their court system, it's not.
There's nothing to it. Okay, so
and I know, wasn't there a bench warrant or whatever they call it in Indiana to bring Richard Allen in for the hearing?
Yes, motion for transfer, and that's still pending too. I mean, that's still on there. The hearing is still scheduled for Monday at 9 a.m. He's still set to be transferred Monday, and she's not done anything with the motions for continuances. Does she have to deny it?
What do you mean?
So let's say she doesn't do anything.
Deny the motion to continue? Correct. You shouldn't have to do anything. But tell me what you're thinking on that. Maybe I'm not understanding.
So I'm just wondering, so like they motion for a continuance and she either grants it or denies it. Does she have to do one of those things, or can she just leave it how it is right now and see if they show up?
Oh, I see what you're saying. Since they filed a motion for continuance, if she doesn't rule on the motion for continuance, that's a really good question. Either granting or denying it, then it stays status quo. In essence, by not ruling on the motion, she's denying it. You understand what I'm saying? She doesn't.
Yes, that's what I was wondering.
So she doesn't need to deny it for the hearing to happen on Monday. That's a good question.
So she does nothing. It's just, it is what it is.
Then everybody, now there's no order that particular defendants or attorneys be present. So if she doesn't grant it because of Rosie's being out of state, don't know what's going to happen and whether Rosie going to change his plans or he can still go and not need to worry about it. That's the way it typically is, unless an attorney is specifically ordered to be there. Another attorney in the office can take it. Now they both have a specially appearing lawyer, Baldwin, lead pipe.
Hennessy?
Yeah.
Lead pipe. That's a good one. He is a lead pipe.
Lead pipe carrying MFer. Without a doubt.
Oh, he is. And he does. Yeah, and I'm just thinking for him, like he's in the middle of preparing for a triple homicide defense.
Yeah.
Like, and here he is still having to step in and go back in front of goal and be like, what are you doing? What are you doing?
Yeah. In that case, he had a critical piece of evidence suppressed in the trial court, and the state appealed it to the appellate court on an interlocutory appeal, by the way. And the Indiana Court of Appeals reversed it. So now it's back in the trial court. I can't remember if the Supreme Court looked at it at all, but or if they just said, no, we're not going to hear it. But yeah, it's a pretty serious case, and quite a reversal of fortune on that suppression motion. But yeah, real tough case. And, he'd been around the block or two. He's extremely dedicated to getting proper training and resources for attorneys who handle court-appointed cases, public defenders, which is what the counsel does. There's the Indiana Public Defender Commission, which is different, and then the Indiana Public Defender Council, which he's been on the board of almost since its inception. Everybody's aware that he hasn't tried 100 murder trials. He's won 100 murder trials.
Right.
So I had checked him out, and I was in somebody's chat, Criming Shame. I can't, no, I think it was something maybe Bob was doing. And somebody said, well, who's this Hennessy dude? And some stuff just pops in my head. I can't tell you why, but I said, Hennessy is a lead pipe carrying, spelled out, MFer. Everybody in Indiana who does criminal defense knows who Hennessy is. And, I guess some of the perceptions, it's like, oh, well, for some reason, Baldwin and Rosie would just grab any attorney off the street or something. I think it may have been surprising to a lot of people, the quality, the caliber, and the number of lawyers who have come in to argue on behalf of these principles. It's not so much people shouldn't get confused or get the idea that, oh, look at all these attorneys who think Richard Allen is innocent or not guilty, or
Right.
they're not really jumping in. They may be, I don't know, but typically they're jumping in, and like the case of Princess of Effing Darkness, she knows more about that access to court records act than anybody in Indiana probably. And they asked her, and fortunately she said yes. And Kara and all of these lawyers coming in, there's I know it seems like a circus. Well, it is a circus. It's beyond seemingly. It clearly is a circus, but it's a circus because there's not an apprehension of the background. So an analogy, to have, a good house or a building, you need what? You need a solid foundation, right? So in the criminal justice process, the foundation is the constitutional principles, and then the things that derive from that we call due process, right to a jury trial, right to be able to talk to your attorney in private, right to not have your defense attorneys fucked with by the court. That's the foundation. And it's when attorneys on whatever type of case, this being a criminal case, where they see the foundation being messed with, that can include the way that attorneys got replaced and had the counsel come in and file an amicus about, you don't want a system where the judge says, oh, I don't like the way they're handling the case, I'm going to remove them and appoint, now in my area, it would be, appoint 2 lawyers that contributed significant amounts of money to that judge's campaign, maybe. Or people that would, feel more pressure about not upsetting the judge, whereas Baldwin and Rosie clearly don't care what the judge thinks. I think they're working in an ethical manner, but they're not filing or not filing things based on what they think is going to upset or please the judge. And to his credit, sorry about the name, they filed a motion in 27 years or whatever it was. I have 37. 27 years, I've never seen this situation of having to talk to a client in a jail or prison, that's pretty strong condemnation. And then somebody brought up to me over on Crime and Shame, somebody mentioned in chat that the last bills that Rosie and Baldwin submitted took 4 or 5 months. Took 4 or 5 months to get paid, and that's deeply troubling because a case of this magnitude, and they've already submitted bills for 1,000 hours or 2,000.
I don't remember the amount of hours, but it was a lot.
Okay. So 500 hours each, that's essentially 1/4 of the year, 8 hours a day, 5 days a week on the case. Now, obviously you don't work it that way, but it's significant amount of time every week, week in, week out. And which means you cannot use your time on cases that pay hourly, or, you know, it's an income hit if you're not being paid, and doing that could put you completely under. You know, you start to have to lay off support staff. I'm sorry, you know, the court's not approving our bills. I'm going to have to lay you off until we get paid. And then it's even more inefficiency, and, you know, it's a spiral, and you can't have that. So of all of the things I've heard, that's been the most troubling to me so far. I was kind of in a, well, we need to wait and see, and kind of figure out how this goes. And then, but when I heard that, I was kind of like, maybe she does need to go.
What do you think Nick would do if he wasn't getting a paycheck?
Yeah, you know, you however it goes there, some counties allow you to bill every month, or someone at every quarter. But where I'm at, they typically pay, depending on the county, between 10 and 30 days. I really don't take any court appointed unless a judge asks me to, and then I typically take that pro bono. But you know, I don't do a lot of that anymore. But that's the way it was when I was taking court-appointed cases. You just can't have it. That's, in essence, messing around with the court-appointed attorneys. And you just think of all the indirect ways you can manipulate the defense by how quickly you get their bills paid. Now, the process is same here. The judge looks at it, and then I heard it sat on her desk, and then I thought, well, you know, benefit of the doubt. Well, she was ill for a while, and then somebody said, no, this was back in August, and then they were calling, and finally the judge approved it, and then you know, then it goes to the controller, treasurer, you know, whatever they have in place in that county. But it seemed like the log jam was with the judge, and that's deeply disturbing. I don't care what side of this thing you were on. Could you imagine if the prosecutor didn't get a paycheck for 4 months?
Right. He'd be crying at city council. I need my money. I can't do this. I need my money.
Right.
I don't know. I don't know what's tomorrow going to bring, Travis. What are we going to see tomorrow?
Well, maybe Sleuthy's right. Maybe she'll rule on that motion, and, you know, continue it. I don't know what we're going to see tomorrow, but this case is never short on excitement. As soon as you think, oh, okay, well, all of the big stuff's over, this big fight, which those fights were worth the fight over the right to counsel a choice, and
right,
especially if, you know, your subscribers look, okay, we're going to lock down discovery, but there's rules, you know, and if you want stuff sealed, you got to do these things. It's not just up to the judge to determine what it is. And if they decide something is appropriate to be sealed, or confidential, you need to state the reasons so enough that a newspaper or anybody can go in and challenge it. And, I don't know. We got a lot of things where it looks like it's just corners are being cut, and then it turns more serious that we're impacting which attorneys are going to be on a case, and then lead pipe comes in and says you can't do this.
Right.
Turns out he's absolutely right. Now we got a couple of more things coming up. So I really like the way you narrowed this down to the fundamental question, which is she going to listen? Which is shorthand for, do you think she's going to give what's been filed serious consideration? Because the outward appearance, I think, what a lot of people have a problem with, the outward appearance is she's not giving due consideration to what's been filed up to this point. Is that
Correct.
a fair assumption?
Yes.
That the general people that have a problem with her, it's generally that they don't think she's giving the attorneys and, more importantly, Richard Allen due consideration based on their written submissions. She's not giving hearings. She allows TVs in the courtroom when she knows there's not going to be a hearing, and then denies TVs in the courtroom, television in the courtroom, when there's going to be more of a blow up, because she knows lead pipe's going to be there.
She's not going to want to talk too much to him. I think that I was surprised she actually let him talk the last time. So BH actually has a really good question, and then I have to wrap it up because I have to go pick up my daughter from gymnastics. But I want to make sure we get this one because this is such a good question. What is your opinion on McLeland looking at the work product of Baldwin via the text messages between Baldwin and Mitch?
I'm glad that question came up, and I'll try and be real quick on this because I've been giving that some thought. I don't know the specifics, and I don't need to know about the work product or what it was, but I know they got stuff with search warrants or whatnot that included emails that could be work product. This issue actually comes up a lot where somebody's under investigation and it's in a grand jury. And so they go and hire an attorney to represent them and give them advice. Should I testify in front of the grand jury, not testify? Should I go down and give a statement to the detective? What should I do? And so there's all types of communications. There's phone calls between me and client who's subject of grand jury. In this day and age, there's texts back and forth, there's emails back and forth, and the grand jury indicts that person for whatever crime. And then frequently what you'll see when the indictment comes out, there's an arrest warrant and then a search warrant to search one of these, which is essentially a computer. It has all their emails, all their texts, all of my emails, all of my texts. And so what we do is we go in and we say, well, Judge, they got the search warrant. We're asking you to quash the search warrant or put in parameters where a third party is going through their phone and they're given instructions to not turn over. It's called an extraction report in a phone. Not turn over any of the emails between my office and my client, regardless of the time, any text messages. And there's case law that says if a DA doesn't do this, and this is what's important about this case, and that a DA who knows he shouldn't have been looking at it and did look at it can be disqualified from the case. There's lots of case law about that. And this is where it happens all the time, is search warrants for phones where in situations where you're being investigated, there's a grand jury, and so you're having communications with an attorney about that and getting advice, and it can't be used as a means to prevent evidence. In other words, a client can't come to me with their papers evidencing income tax evasion, for example, a second set of books, and say, hey, can you put this in your safe for me? No, you can't do that. But if I ask them, please give me a summary of everything that's going on and address it to me, they cannot get that. So things that are in existence and evidence of the crime, it's not going to protect that. And that's not what we're asking the court to prevent. What we are asking is that communications between now work products a little bit different. So that's attorney-client confidential communications. Attorney work product is, and I don't know how they would have this, but if they're, and it's not as common of an issue, but work product is like, talking with a collaborator. And I know there's this one person that, he's faced the Westerman, supposed to be a collaborator of Baldwin's. I don't have a problem of collaborating with non-lawyers. It happens all the time. We talk to our legal assistants about cases, trust them with discovery, paralegals, private investigators. None of them are lawyers, and we trust them with very sensitive discovery materials. Those of us who are prudent, we get them to sign a non-disclosure, but if somebody's going to do something, they're going to do it. But sending somebody to a collaborator, hey, what do you think about this? It's less of a problem for the state. I don't know what the law in Indiana is on it. It'd go court by court. It'd go court by court here, how upset a judge would be with a prosecutor about that.
And Nick, looking at the messages between Baldwin and Mitch Westerman, where he even states something along the lines of like they were speaking candidly about essentially him and the judge.
Oh, great.
Why would that even be? Yeah, why would that even be pertinent to anything? Why would he even if he was allowed to look at it based on the investigation, that would have nothing to do with the investigation of them talking smack or whatever they're doing about the judge and Nick. Yet he puts that in his motion.
In a general way, in a general description, or did he? So that to me is like a threat that you better reconsider this bias motion, or because we could end up with, and then boom, again, how these things are getting scheduled and who's participating. Yeah, you'll file that. You'll mention in there that you've got attorney work product communications that are talking about the prosecutor and the judge. And then judge, I mean, if you could do it this way, and then judge, you then order that hearing, and then we'll see what they do about that.
Right.
So it just makes me question more about the scheduling of things. That you're absolutely right. Putting that in the motion, and that doesn't further the investigation in any way. And it should have been walled off. And it's just say, hey, there's stuff with the attorney about, okay, I don't want to see any of that. That could get me disqualified. If we need to get into that, we'll figure out a process for it. But I just need the stuff about relating to the violation of the order. Unless part of that conversation was somehow telling Westerman to violate the order or disregard the order, or I don't care about, absent that, you're absolutely right. It's not appropriate for the DA to look at it. No reason for the DA to look at it. Could have been filtered through an investigator. And then he puts it in there, and then boom, it gets set for hearing. It's kind of this MO about, we'll embarrass them off this case.
Yes.
But
that's
how's
exactly how
how's that working for you? And who's becoming, who's having the most embarrassment about this stuff? I mean, Baldwin and Rosie are essentially criminal defense martyrs. I mean, I don't think anybody in the criminal defense bar would have anything negative whatsoever to say about them. You'd like to think that these, and then I'm going to let you go, that that there aren't these underlying motives about all this stuff, but we're left with the decisions being made on these motions, and the conduct of the court is just so far out of left field that you kind of hope there's some motive to it, because there's, as somebody a lot smarter than me said, these principles are older than dirt. Well, thank you for having me on, and know you got to go pick up the future.
I owe you a huge debt. I have a huge debt of gratitude to you.
I've been wanting to come on for a while. Next time we'll plan something. I really enjoyed it, and I didn't have it set up tonight where I could see the chat. So if people were saying hello or saying, get this guy off, he's full of shit, I couldn't see it. I apologize. I wouldn't.
Nobody said that. Nobody said that at all.
But
everybody was extremely
hello back, and if it was helpful, I'm glad. If it wasn't, I'll try harder next time.
I think you did absolutely amazing. Everybody's been extremely thankful, talked about what a great guest you've been and how knowledgeable you are and how calm, cool, collected you are. They want you to come back. This was amazing. One of the best shows. Well, so full of compliments. Everybody is extremely appreciative of you, including myself. And then you got a boom also.
Boom. Okay. So thank you for having me. And, you'll sign off, and then I'm going to give you my email and phone number, text number.
Okay.
So that if you have something come up in the future that's more law related, and Bob's not available, you can always give me a jingle. But thanks, everybody. I appreciate the comments.
Thank you so much, Travis. Thank you. And thank you, everybody. I appreciate each and every one of you guys for spending your evening here with us. And I know you have 1,000 other places that you could spend your time, and you guys choose to spend your time here with me. And thankfully tonight I had some backup with some legal knowledge to walk me through this new document. So I will see you guys. I'm going to see you tomorrow, because that's just, I feel like where we're going to go. I think I'm going to see you tomorrow. So we're just going to say that. So go have a good night. I'm going to go pick up my daughter, and we'll be back. See you on the YouTube streets before then, I'm sure. Have a good one.